Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don, thanks for coming on the show.
Thanks for having me, Jim.
For our monthly update this month, okay?
Sure.
Before we get into that, let's just tell our viewers a little bit about yourself.
Well, my name's Don Ross. I have a Ross Title and Escrow here in Naples. I'm the attorney for Downing Fry, have been for 25, 30 years. I'm one of the owners. Have a law firm. We have 7 closers at the title company. We do quite a few closings. We're right across from Pastrami Dance. Every guy in Naples knows where that is, corner of 6th Avenue North and 41. People have been with me a long time, over 30 years for one of them. So a good, tight-knit group. We try to return our phone calls, try to treat people well, and hopefully they're happy.
Yeah, they're very happy. At least our clients are. In
thanks.
fact, yesterday you picked up the phone and answered some questions for one of my clients that's buying
She's
in
a
a
nice
new
lady.
development. Right. So, I wanted to start off. We're going into season, okay? It's really started for us in the last 3-4 weeks, even though we are year-round here in
Sure.
Naples. But real estate disputes. So, I want you just to you got a list there. Let's just go over them one by one, the most common ones that you're seeing, because you're doing the closings, and, we don't hope, in our group, we don't have a lot of real estate disputes, but knock on wood here.
Well, I mean, there are a lot of disputes. There are a lot of the way the contracts are written. They can be interpreted different ways.
Yep.
They're deliberately ambiguous in some regards. Like something has to be in working condition, whatever that means. Say you have a slider and it's a little tough to close. Is that working condition? So they're vague or elastic might be a better term, to accommodate unforeseen factual situations when they drafted the contract. You're never going to have a perfect contract.
No.
It's not possible. So there are a lot of disputes or disagreements on interpretation, might be a more polite way of putting it, even before the contract gets signed. I mean, I had one this morning where we had a Naples Board of Realtors as-is contract. We got a FAR lease that goes with it, and then there's an addendum for an option to buy, and they're all, one's FAR, one's NABOR, and gosh knows where the addendum came from. I don't know, and my client is the owner, and he's a very ex-military wealthy person who doesn't like a lot of he likes it straight, simple, clean, and
That's
clear.
Right. Like being in the military, right?
He flies all over the world, and he straight, simple, clear. He doesn't have to sell this thing. So we're at the point where I'm discussing with the other attorney, why do we have 3 different forms? Why can't we do this with the 1-page addendum? Why can't we allocate more of the money to the lease so he has money in his hand rather than waiting until next May to close and get paid, and when he really doesn't have to sell it? He's a very wealthy guy. So I get a lot of things like that where we're arguing over the forms. I get a lot of questions from realtors, in fact, on, it's in MLS and they'll only take FAR as is, and what happens, can I use the NABOR? And everybody wants to use the form they know. You can't know all 150 forms.
True, you can't.
Unless you really focus and put a lot into it, go to law school, hopefully. So, pre-contract, I get those. I get disagreements on the lease itself. I mean, as the attorney for Downing Fry, I get all the northern attorneys who are listing their property, and they don't like the 14 different provisions in the listing agreement that we use here in Collier County, so they want to eliminate the part, for example, where the realtor gets a portion of the deposit if the seller forfeits it when the buyer fails to close. That's in there. Or they're always Xing out the remedies that the broker will have against the owner if the owner refuses to accept a full price non-contingency offer. Or they don't like, there's a part of the listing agreement that has what will be in the contract, what the standard provisions in the NABOR contract. They put that in the listing agreement so that it's easier for the broker to claim their deposit if the seller just says, I changed my mind, I don't want to sell.
Right.
And they got a full price offer. It complied with all those terms in the listing agreement. So I get a lot of that beforehand. I get the people who come in and their friends, and the seller is foreign and they want the buyer to sign. There's an addendum that if the buyer signs this addendum saying it's their intention to reside there at least half the time it's in use, that if it's under $300,000, the seller doesn't have to have withholding going to the IRS. If it's over $300,000 to $1 million, it's dropped from 15 to 10%.
Right.
So they want the buyer to sign that up front. And if I'm just on the buyer's side, I'll be saying, let's see how they respond to your inspection request. If they're nice people, if they fix legitimate things, leaky faucets, a leak in the roof, a broken air conditioner. If they treat you well, you treat them well.
Right.
And so it's a leverage tool that frequently I run into, and people are arguing, I want it now, and well, you don't have to do it now. If you treat us fairly, we'll treat you fairly. Is usually how we do it. Negotiating the contract itself. Again, this morning I had a second one, and it was a farm bar as is here in Collier County.
Mm-hmm.
And I had the realtor and I had the prospective seller on it, and I had to point out that they had the seller paying the title insurance, because the realtor comes from Fort Myers, and that's
right.
what they're used to, and
Yep.
so you want to change this. And my realtor
Right.
who referred me the closing or the potential closing doesn't like the form because she doesn't know the form. So I said, that's all right, I know the form, and we can make
Work
this
through it.
change.
Right.
And there's a due diligence period, and then they had a mold addendum attached to it, which is overkill because you already have the right to cancel for any reason within 15 days anyways.
That's true.
So
yeah.
you can do whatever mold inspection you want within the 15 days. You don't need to have a separate contingency, which a lot of people will line up 2, 3, 4 contingencies that all could have fit within the 15-day due diligence.
Mm-hmm.
So there's a lot of fighting or disagreeing on which form to use and why, and who's paying for title insurance, and how much is the deposit, is that enough? When's the second deposit due? It's strategically after the inspections are done. So there's a lot of that going on even before you have a contract. So and again, a lot of times the people want to meet you because they're not used to doing closings here in Naples. They're from somewhere else, and they want to feel safe dealing with us in this case.
And giving them their money too. So.
Yeah, they want to walk out feeling confident
Right.
and understanding the documents they're signing.
Mm-hmm. Don, we're going to take a little short break.
Sure.
And we'll go into the part 2 of this conversation, and we'll be right back, and we're going to have a little break about Don Ross, his company, in
good.
York Real Estate Group. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, Don, we had a nice little break here, so let's continue this part 2 of the conversation, okay?
Okay, well, now we're post-contract. You actually negotiated a contract. You negotiated the
Thank
proper
God,
form.
right?
Yeah. It is as much work creating it as completing it.
That's right.
But anyways, the once you have the contract, then you get into inspection issues. Inspection and finance are probably the top 2 things that occur post-contract. The inspection process, usually people don't fully understand it. they're applying common sense, and the law doesn't have common sense for the most part.
No.
You know, and I have to go over the 15 days, and there's a lot of arguments in many cases over whether something's in working condition or not. Both NABOR and FARBAR require that, you know, the appliances and the windows and doors and all that be in working condition. What's working condition? It's working in the way it was designed to operate. Sounds simple, really isn't.
You know, I explain that right up front when we're doing the contract, because you know, we're either doing an as-is or just a regular contract, and because I think that's where one of the biggest problems are is that if it isn't in working condition or if it's broken, how much is it worth to replace that?
Well, and with NABOR, we have that language that the seller is not obligated more than the fair market value of that particular item, if it were working correctly. But what is working correctly, say, with a window where you have to crank it to open it, it's a little difficult to open, or sliders where you have to apply a little bit of muscle to open the sliders? Is that working condition?
Right.
You know, is it 10% harder, 20%, 30% harder? At what point, especially if it's a 15-year-old set of sliding glass doors?
Right.
So, you know, we get a lot of that. You know, you get the fogged window. In NABOR, it doesn't really talk about it. In FARBAR, it says fogged window is something that would have to be addressed. You know, the cracked tiles, well, that's cosmetic in NABOR, but at some point, it doesn't say anything about broken tiles or missing tiles. You know, is that an issue? That's, depending on who you talk to, it is or it isn't. Mold, I had one this morning where the buyer just wants to cancel the contract because they have some mold that comes from decaying sheetrock. They got some rain with Irma, and the seller got a brand new roof. It's an elderly lady, and there's a little bit of sheetrock around the front door. And the mold inspector, if you read the beginning of the report, it sounds like the world is ending, and you got to put a hazmat suit on and, you know, replace all this. But then when you read the actual mold report, where they have the bar graph and you can show the outside and the guest hallway and then the master bedroom, which is what they did in this case. You look at that and you say, well, outside it was 0, which usually is atmospheric, could be weather, could be rain. One hallway was good, the other one had a number. And they're comparing it to the outside, which is the standard in the NABOR contract, so you could have the number 1, and that would be bad under that report. But then you look at the definition of the mold and you find out it's not toxic or pathogenic, so technically it's not a defective thing in the contract. So after we're done with this, I have to call the buyer and say, technically under the contract, this is not defective. And without looking at it, without having somebody else look at it, it may be remedied easily just with a new piece of sheetrock near the door.
That's right.
And perhaps a UVA light if you have allergy issues, which a lot of folks do. So I get a lot of inspection issues. I get a lot of issues where we have the NABOR form, the buyer's election, seller's response, and they'll sign it before they ask me, do I have to fix this? And what they're being asked to fix is, the question is in a very broad, ambiguous fashion where moisture detected, please fix. You know, am I fixing a pipe? Am I regrouting? Am I just letting it dry out? You know, what caused the wetness? It's not clear. So I'll get the questions after the seller's having a hard time fixing whatever it is, because the question wasn't properly phrased. It wasn't clear. You know, what's broken? What do you want me to do specifically? And I'll say, gee, I wish you hadn't signed this form because that's not defective under the contract. But, you know, so that happens every other closing, honestly. The other biggie is financing. And I had this one this morning too. My client has $80,000 down, and under paragraph 4 in the NABOR contract, you basically need something in writing from the lender or creditor saying why the person is being turned down, or if they're not being turned down and the loan's not being granted, you know, something in writing saying the person applied on time, they made a good faith effort, but we just can't get to it for whatever reason. You know, I got one where he was turned down. Well, there were 2 turn down letters. One saying they weren't able to verify certain information, which to me is a big, huge red flag and not good for my client. The second one said he's being turned down because there's a 12-month lease and he doesn't qualify as a second home with, it was Quicken Loans in this case, because of the 12-month lease. And the seller wants to be reimbursed for attorney's fees. He has $80,000. I'm talking to him on the phone on the way in this morning. He said, well, I can sue and fight, right, Don? And I said, well, you could sue, but you know, lawyers are expensive. They're going to want a retainer, maybe $5,000. Sure. And anybody who's ever been through a lawsuit knows those aren't a sure thing, no matter how good a case you have. Right. And with men, I know it's probably a little sexist. I'll use Vegas as a metaphor and say, you know, let's make up the name Joe. Joe, you know, would you gamble $80,000 to win $2,000? Right. You know, if you were in Vegas, and I don't care what the odds are, and this is exactly what I was saying to him this morning. And the odds were very good. They were. But you're going to spend 6 months of your life litigating this, hiring somebody, potentially losing. There's always a chance. To gain $2,000, if that's what the seller's attorney's fees might be. Right. So that's a routine thing, and I get a lot of folks who are, it's not fair that they have to do that. It should just be given to me because I got the letter. Right. And it said, nobody's going to release an escrow deposit unless both sides agree to it, unless it's within the condominium review period, the 3 days, or unless you're within a due diligence period where it's in buyer's sole discretion. Right. I mean, anything else is a question of fact, and no title company, no law firm is going to release that money until both sides agree, because we don't know what happened with the lender. We don't know. I didn't go look at the house to look at the mold in the prior example, so I don't want to be the judge and jury here. Let somebody else do it. So those are the two post-closing biggies. The third, and this is probably it, would be escrows. Escrows are a living nightmare. The contract provides that if the seller agrees to make repairs and it's not done by closing, you'll escrow the estimated cost to complete the repairs. Well, if it's a permit, nobody has any idea what it costs to close it out. Right. Don't know if the county's going to require you to replace something, so it's impossible. And if you're doing your walkthrough the day before and you find the seller didn't have time to fix the air conditioner, you're not going to get an air conditioning company that day to give you an estimate on what it's going to cost to finish it. Right. So, you know, there's always an argument over how much of an escrow and how long it's going to be held before the money goes back to the seller or to the buyer if it's not done. Right. I mean, none of that's in the contract. No, so is it 30 days? Is it 60 days? I mean, after Irma, we were in uncharted territory. We were doing like 9 months, 12 months, because we had no clue, you know, when somebody would be able to fix, for example, a leaky roof. There were so many bad roofs at that time. So those are the three areas: escrows, finance, and inspections. That if you don't know those, you're going to have a hard time with your closings. Yeah, well, Don, you've covered a lot today, and I know our closings, I think the big thing is communication and explaining it. Yes. I mean, you know, that's, sometimes I talk too much, but I'm always trying to educate my buyer or seller, I mean, about the contract or what can happen, what not can happen. And I've learned a lot of that. I'm thankful for you, because being on the show and us doing so much business together, I've learned a lot of these things. That's valuable information. You prepare them ahead of time. Right. I had a buyer who, when going over the contract, and I would tell him, for example, with the air conditioner, you don't get a brand new one if it's 10 years old. That's right. I say, but it doesn't mean we're not going to ask for it. I just want you to know that you're not entitled to it, so you don't get angry if you don't get a brand new air conditioner. And that's exactly the truth. I mean, it's just explaining really what everything, and knowing the contracts. I mean, some people think showing the property is just the easy part. It's really, you know, it's the contract is the hard part, because you're taking somebody's money, you know, and it's an emotional experience for sellers and buyers. They don't do that many, most people in their entire life. We've done a lot. That's right. You know, to them it's a really huge thing. It's a huge thing. Well, thanks for coming on the show. Oh, thanks for having me. Enjoy it. I'll see you next month, right? Absolutely. Okay. Thank you for tuning in today, and we'll see you next week. Thank you.